Number 2 on our docket, I have Kimberly Carroll present. Case was originally filed as Kimberly Seraphin. Do I have Eddie Seraphin on the line as well?
Yes, Your Honor.
Okay, thank you. And then we have Ms. Turnbull here. This was just set as a review for GAL compliance. My notes suggest that this was just going to be a quick review to make sure a payment had come in. Ms. Turnbull, what can you tell the court?
Mr. Seraphin has paid his fees. We've had an interview, and I would say he's in compliance at this point.
Okay. And then I'm just going to, oh, my computer kicked me out. Let me get back into today's docket. Did we already set a forward date, or do we need to do that today?
I am going to have to check.
See, my computer's working now. I'm not showing that I set any future dates yet.
I don't have anything, Your Honor. So
okay. So now that we are in compliance with GAL, essentially the court will be waiting on some input from the GAL as we move forward. What kind of timeline would the folks be asking for?
Well, go ahead. Ms. Carroll has asked for a little bit more time to finish paying her fee. She's asked for, I want to say mid-January, if I recall correctly.
Okay.
So I would say at least, maybe end of January.
I want to go here.
Okay.
Public? Please don't. Mom, please don't.
Please mute yourself on the iPad that just plugged in.
I don't want you to. Please. Why? Because I cannot be distracted.
All right, I'm going to go ahead and mute that person. So we could set this for Wednesday, January 31st at 9 a.m. Would that work for the parties?
That's fine with me.
Okay, and we'll go ahead and just set this on for GAL review and anything else the parties need today. Mr. Seraphin, thank you so much for getting all of that done.
You're welcome.
Okay.
Anything else that I need?
Adulting, we'll try to drop it off right
now. And please mute yourselves if we don't have your case in front of the court. Okay. Okay, thank you all. You're free to log off on this matter. Mr. Lawrence is on that case with us. And then do I have Elisa Gutierrez and Francisco Gutierrez?
I'm here.
And
I'm here.
Let's see, Mr. Gutierrez, what account are you under? I'm not seeing your name.
I'm on my phone.
I see you now. We have so many people on screen. I just had to see it light up when you talked. And I know Ms. Gutierrez, when we were here last, we were missing you.
Yeah.
So what we did, I know that you had been at all prior hearings. I wasn't quite sure what had happened, but essentially what we were waiting on at that time was Mr. Gutierrez and his counselor, particularly the counselor, to get more information to the GAL. So we just went ahead and set today as the review date for that information. Okay, so Mr. Lawrence, go ahead.
Your Honor, at 3:56 p.m. yesterday afternoon, I received an email from Julian, and he had forwarded his evaluation from Kaiser. And I believe he also forwarded a copy to Elisa. It indicated that he did have a relatively minor problem with alcohol. They were recommending outpatient treatment for him. And I wasn't aware whether Elisa had gotten a copy or not, so I forwarded my copy to her and reminded her of today's court date. I'm sure that Mr. Gutierrez has not had a chance to file it with the court, and I may have to file it so that the court has a copy in the file. But right now, that's where we stand.
Okay. And then that outpatient treatment, is that something that's been undertaken or is happening, or do we know?
Your Honor, I don't know at this point. Mr. Gutierrez will have to answer to that one.
Okay. Mr. Gutierrez, what can you tell me about any treatment follow-up?
As far as right now, I don't I don't have any treatment. What the counselor said to me was that it's just considered a level 1 outpatient treatment, and it's pretty much like up to me if I want to do it, or basically up to, I don't know, the court. If I'm being ordered to do it, she just said it's just a level 1 outpatient recommendation. At this point, I feel like I guess part of it is up to me, I guess, and part of it is if I'm being ordered to do it. I just don't know.
So I don't have the documentation in front of me, but I'll tell you just in my experience, both as an attorney and a judge, that typically evaluations like this are written in terms of recommendations. So a medical provider is never going to say, I order you to do level 1 outpatient treatment, but certainly the court's expectation when we require evaluations is typically you get the evaluation, the expectation is that you comply with the treatment recommendations. So I don't know if the word recommendations is what's tripping you up there, but it is this court's expectation that you would comply with the recommendations of the professional. Is that helpful to you?
Yeah, I guess I'll have to do it.
And Mr. Lawrence, since I haven't seen that document, is that accurate that following the evaluation, it's level 1 outpatient is listed as the recommended treatment plan?
Yes, Your Honor.
Okay. So my thought on this case, Mr. Francisco, is to set a further review date to just check your compliance with the level 1 outpatient treatment, which is one of the lowest levels. So it should be pretty easy for you to accomplish. How does that sound?
I'll look into it after I'm done here.
Okay. How much time would you want to get that started? And we'll just set your next review date accordingly.
I'm hoping sometime next week. Like I said, I will reach out to the counselor. I'll reach out to whoever I need to, hopefully by the end of today or the end of the week, and get this thing started for myself. Excuse me.
I'm going to set it out a little more than 1 week, just because although you might have answers about when and how to start the level 1 treatment, I don't think you'll actually have started that. So my proposal would be that we set this out to January 17th at 9 a.m. if the parties are available for review.
I think that's fine.
Yeah, I'm available. Yes.
Okay, great.
I'm available as well, Your Honor.
Okay, great. Thank you all for that. So what we'll do, Mr. Gutierrez, is just your only task for the review on the 17th would just be to give an update, hopefully showing that you've been started to engage in some of the level 1 treatment, and then we'll go from there. Okay.
All right.
Okay. Anything else we need to do on this matter?
I don't believe so, Your Honor.
Okay.
I have a
There's anything from you?
No, he's been doing very well at staying in contact with the kids and showing up for visits now, so I'm very pleased with that.
Good. And we still have Sabrina supervising.
Yeah.
Okay. Mr. Gutierrez, go ahead.
I just have a question about basically the bills that have to do with the house. I don't think Elisa has removed my name of all the bills, which they're still being forwarded to me, and I don't know if I should be talking about that on here to you or with Lawrence or.
Well, so we're here just on an adequate cause to change a parenting plan. My understanding is you all back in June of 2022. I'm just going to check to make sure this is accurate. June 2nd, 2022. You guys do have a decree of dissolution that controls debts and all of those things, real property. I don't know if you're talking about the 48th Avenue location.
Yes, I am.
Okay, so go check your June 2nd, 2022 divorce decree or decree of dissolution, it does list specifically each of your obligations with regard to that property.
Okay.
Okay. All right. Thank you so much. We'll see you back on the 17th, Denzel Westlean.
Thank you.
All right.
Yes.
Okay.
Mine's muted. I don't know how to mute it. Yes.
Okay. And I'm just looking for the other party. Are you both?
Yeah, we're both here. We're both sitting in the same room even.
Oh, look at you guys. Wow. I am in. Okay. Well, you're sitting in the same room. It tells me things aren't going horribly. Tell me where we're at with regard to this review.
It's all done, taken care of.
It is all done. Okay.
All the financial stuff got all took care of.
Okay. So everything got transferred appropriately.
Yes.
Okay. So then what I'm inclined to do, and I'm just going to pull up the original motion, since ma'am is Westlean, it was your motion for contempt to move this along. It sounds as if you are withdrawing your motion for contempt at this point. Is that accurate to say?
Yes, ma'am.
Okay. So what I'm just going to note in my clerk's minutes is that Mr. Westlean has fully complied at this point. It took us a little while to get here, but I'm very glad to hear that you are both at this point. In fact, sitting in the same room even. So you win today. And I will just go ahead and strike your contempt motion, or excuse me, I'll not strike it. I'll note that you're withdrawing your motion for contempt at this time.
I think he won today too.
Well, good. Good to both of you. Anything else you need from the court? It sounds like you all can be done with us.
Yeah, we're fine. I'm through.
Mr. Westlean, anything you need from the court?
No, I don't think so.
Okay. Well, nice to see you both. And we probably don't need to see you again. So take care.
I don't know. We might want to just see your smiling face.
So anytime. Really proud to see where this started. I don't know if I would have guessed we'd ended up right here, but good job.
Yes.
Great
I
job.
agree. Thank you.
Yep, you're
Thank
welcome. Do I care? Ashley present?
You too.
Yes, ma'am, I'm here.
Okay. And then I do see Joseph there. Mr. Lawrence is with us. On this case, I did receive and review Lawrence's report as it relates to getting some sort of temporary order in place. Have the parties both been able to review his recommendations?
Yes, ma'am.
No, I didn't get anything.
Okay. And I'm going to turn it over to Mr. Lawrence here in just a minute, but I'll just let the parties know this case has had, a lengthy history starting back in 2019. And I know you're most recently in front of me because there was an adequate cause motion filed to change a parenting plan. But upon further glance of the history of this case, it does not appear that there was ever a final parenting plan signed by a judge. So essentially, I'm just making a specific finding that I don't need to address the adequate cause motion. Really what we're here on is to set temporary orders and then ultimately final orders. So Mr. Lawrence, go ahead with any input you would like to give the court. It sounds like we might have an issue where Mr. Becerra hasn't yet received your recommendations.
Your Honor, I emailed, and I always ask clients whether it's okay to serve them via email, and he had indicated yes. And I sent the report last week to his email at the email address that I have in the file. And I've sent other stuff to Mr. Becerra through that email and never had a problem. So I don't know why he didn't get a copy of the report. As far as the report itself, it's pretty extensive. I would ask the court to follow the recommendations.
So, Mr. Becerra, are you able to check your email to see if you have it?
Give me 1 second.
Okay. And I'll just tell you, this is a case where I really will need Mr. Becerra's input. There are some recommendations that I think financially could impact you that I wanted to talk through today. Mr. Lawrence's report is very thorough and very detailed with very specific recommendations. And some of those recommendations, I need to chat with you, sir, about, whether these are things you can actually get done. Oh,
Sorry.
No, go ahead, sir.
So I just checked my email, and the last email I got from him was on the 4th of December.
And is that's not the report?
No, that was saying that he was asking for a continuance.
Okay. Oh yeah, that was right before our December 6th hearing. I don't want to prolong this. Could we set this over just to next Wednesday? I don't know if the parties are present. I know that's a holiday week.
Ma'am, I would prefer if Mr. Lawrence could maybe try and email that again to Joe to have him review really quick. Because my son's due to go back to him this weekend, and with those recommendations, I don't feel that that's the best in my son's interest.
Well, I understand, ma'am, but I have some heartburn about the recommendations. I think some of the things, based on what we actually have evidence of, are not things I'm going to be doing, but I really need Mr. Becerra to have reviewed the report in its entirety. There are things that I am likely going to recommend, but I am not, without Mr. Becerra reviewing that report, I'm not making changes to visitation today. I would ask that the report be resent to Mr. Becerra. Mr. Becerra, if you don't receive it by the end of today, please reach out to Mr. Lawrence so you guys can figure out an alternative method. And then I'd like to set you on to next Wednesday at 9 a.m. to go through what I believe the temporary order should look like. And I am likely going to be discussing some options with Mr. Becerra to address some of the concerns Mr. Lawrence raised.
Yeah, when our son was in CPS custody, he never finished his second psychosexual evaluation that was required by CPS.
Yeah, that is.
So that's kind of.
Yep, those are definitely things we're going to talk about. But I have to take into account that most of what is being said are allegations right now. And so I'd have to tread lightly on what I'm actually going to require Mr. Becerra to do. Right now, supervised visitation is in place. I understand there's a question about whether
No, it's not. He's not being supervised. He's being monitored by his twin sister or his girlfriend's mom and her husband.
So, Mr. Becerra, what's going on with visitation right now?
Your Honor, she is incorrect, and it was put in when we purchased the minutes too. It's to be monitored, not supervised by. I have Michael Wolf, Cindy Wolf, and my sister Michelle Medina, and we are to stay the night with them, and I do every time. And I have Michael Wolf here, so if you wanted confirmation that I stay the night here with him.
I think you're playing a game here, sir. There's not, the court's minutes list supervisors, not monitors.
Yeah, they're with me.
Semantics with me. Hold on. So are you telling me that you're not, at all times when the child is with you, there's not one of the 3 approved supervisors with you at all times?
No, I'm not saying that. No, they're with me. I hang out with them all the time. If we go to my sister's, we're with her. If we go over here, we're with them. We go to church, we do Bible studies. We're here. We're with them.
But there's
I
also
can
a
get
2-hour drive between his sister's house to Cindy and Michael's house.
Sir, you are skirting what supervised visitation is, and I'm looking at Judge Scudder's minutes as well. He specifically uses the word supervisor. He does not use monitor. When the court requires supervised visitation, that means 24/7. That doesn't mean we're giving you an hour alone in the car with the child. It is at all times you have a supervisor with you when you are with that child. And that is because of the court's concerns. So are you telling me that is not happening?
Your Honor, I didn't understand that. I explained to the judge that I have to drive from Longview to wherever I have to. But if it pleases him, I will have one of them all the time. I don't care. Doesn't bother me.
Ashley, are you the one who is doing the meetup location with the child?
Yes, ma'am. I take him up and drop him with his father.
Okay. So then, and are you guys still doing that at the Hall of Justice?
We do it either at the Hall of Justice or at the Three Rivers Mall, just kind of depending on, because I also have to pick up my 12-year-old daughter the same days. So
are just until we're back next Wednesday, when you get, so the visitation will start, it'll occur on Friday. If you get to that location and one of those 3 approved supervisors is not with Mr. Becerra, you do not need to transfer the child.
okay.
Okay. So Mr. Becerra,
And then
go
is
ahead.
there actually a signed order for these visits? Because the last time I went and looked, there was no signed order that says I have to give him to him. There was just the court minutes. We don't actually have a signed parenting plan.
I do see that from the July 14, appearance where the court ruled on visitation with Judge Scudder. I'm not either seeing an order to that effect. A second, I'm looking at the follow-up notes. And I think that's the date also that Mr. Lawrence was appointed. So since that time, it's been review hearings. So no, there is not an order. I can do one today for you, just based on the judge's July 14th order. If the parties feel like that is necessary, I'm happy to get it done. But
I was just wondering, because I've been giving him to him because I thought I absolutely had to. With the new information that Mr. Lawrence has provided, I honestly don't feel it's the safest for my son to go with his father.
Well, I want to be careful here because I'm not going to be adopting all of Mr. Lawrence's recommendations. I think some of it's based on, I as a judicial officer have to determine what I believe there's evidence for and what is speculative. And so I understand the concerns of Ms. Becerra and Mr. Lawrence, but I don't agree with all of the recommendations. I think some of the concerns aren't based in what we have evidence of. I'm not saying that won't change as we go through this investigative process. But right now, what I'm going to say, because I am going to be making changes once Mr. Becerra has a chance to review the GAL report and tell me what he agrees with and what he objects to, I'm going to be making changes on Wednesday. So I would say just for this weekend, please stick to Judge Scudder's ruling about the transfer on Friday, and then coming back on Sunday. But Mr. Becerra, if at any point Ashley becomes aware that there is not one of the 3 approved supervisors with you and the child at all times, she absolutely can come pick up the child. That isn't the judge in what I'm reviewing from the 714 ruling was very clear about that.
Okay, I understand. Your Honor, I did have a concern though. She is, and I have documents a few times now, her car has broken down, and she has gotten pissed at me and cussed at me over text because I said she needed to figure out how to get him to me because it's not my responsibility, as in Judge Scudder's thing saying that we had to meet in Longview. And
I
pretty
have
much telling me that
fixed
she
as
would.
of today. I'm buying a brand new car, so.
Hold on, I want him to finish. Hold on, I'll come to you in a second. Go ahead, sir.
And there's been another time where I've had to go, the first actual pickup, me and my sister had to go to Astoria, all the way to Astoria, just so I could see him.
So what's your
And,
question? What are you asking of me?
Well, I don't know exactly what to do in that situation because I don't want to call the cops on her. But what am I allowed to, what can I do is what I'm asking, because I don't think that's fair.
That her car breaks down so she can't get the child to you? I'm not following.
Well, and my son also told me it didn't break down, that it got hit by her boyfriend. So I don't know. I think he is 4, so I don't know if I can take that, but it's just, it kind of seems like a game. And I don't know. I guess I don't know what to do in that situation because I don't want to, cause an issue.
And you work with the mother of your child and figure out how you both can coordinate transfer of the child. I'll tell you both, as you both are navigating single parenthood, and at some point, I bet both of you will have an issue with a vehicle that breaks down. So please just be helpful to each other. I'm not getting the indication that either one of you is trying to keep the child from the other. So just do your best to work with each other. If she says her car breaks down, find a way to meet her somewhere. Well, we're going to.
Yeah, unfortunately, my car did break down. I put over $1,200 worth of work into getting my car fixed so that I could take my son to his father on his weekends. And unfortunately, everything that I fixed on it has not worked. Fortunately, I am on my way to go pick up a brand new car today that is running from a dealership, so I will have no further issues getting my son up there to his father for his visitation.
Okay.
So it was one instance, the first weekend, it was because my tire blew out on the way there.
Well, it sounds like Mr. Becerra, she is working to remedy that issue. I'm going to see the parties back on December 27 at 9 a.m. And then again, Mr. Becerra, if you don't have that report in your email today, please don't wait till next Wednesday to tell me that. Reach out to Mr. Lawrence. Okay.
Okay.
All right. Thank you all.
Your Honor, before we go.
Yes.
I'd like to ask Mr. Becerra if the email that I have for him is accurate. It's J.
I'd really like to, hold on. I'd rather you didn't say my email to everybody.
Okay. Then I will send you a test email to make sure that you get it. And then from there, I'll send you the real report.
Do you have, I believe you, well, yeah, because I've gotten an email from you before. So yeah, if not, I will call your office.
Thank you.
Yep.
Okay. All right. Thank you all. Someone's talking on the cell number ending in 6972. Who is that?
It's Gareth Clark.
Okay. And were you trying to tell the court something or just give us your name?
I was just saying I was here.
Okay. And then we have Karen Lawrence on this case as well. Good morning, Ms. Lawrence.
Good morning, Your Honor.
Okay, when we were here last, it was December 6th, and I found that Ms. Rook's motion had not been, there was no proof of service that it had been served 21 days prior to the hearing. I had received some additional information from Ms. Lawrence. I had instructed Ms. Rooks to reserve Mr. Clark with documents and re-note the matter. I have now received a note for motion docket that was filed with the court December 7th, noting this on for December 20th, still not 21 days. So we've got a problem there. But Mr. Clark is here So
I'm just,
hold on. So Mr. Clark, have you received the documents regarding Ms. Rook's motion to modify the temporary parenting plan?
yeah, and I haven't turned in the paperwork yet. I have a lot of it done, but I just got money because I had a theft occur, and I wasn't able to pay for, I had no money at all, like, ever since I got my money stolen off my card. And then, so when I went in there, they said that I would have to pay for all those copies, you know, of stuff that needed to be shown, and like, because there's a lot that I need to talk about and explain, and I feel it would be good for the.
Sir, I have muted you because I'm trying to talk. Go ahead and unmute and tell me that you are going to listen.
Okay. Was there something wrong with the thing? Are you there?
Yes, please wait for me to ask you to speak. Okay.
Oh, sorry.
This motion by Ms. Rooks was not timely by any stretch of the imagination. We talked, Ms. Rooks, last time about you need 21 days notice. You filed on the 7th and noted it for December 20th. It is not time, ma'am. Everyone, let me finish, and I'm going to give everyone a chance to speak. I promise. This is not a timely motion in front of me, so I am not going to be making a decision on any of it today. However, Mr. Clark is here. He has indicated that he wishes to file a response. He has that right because, again, this isn't a timely motion. So, Mr. Clark, because this was not timely served on you, we can go one of two ways. We can have Ms. Rooks renote this out beyond 21 days from the date she served you. Or if the parties just want to agree on a new hearing date, we can do that here today.
May I speak, ma'am?
Yes, and Mr. Clark, whatever new date we set, if that's the direction we go, will give you time to file the documents that you want to file in response. So what is your preference for proceeding?
I would like to set a date.
How much time do you need to respond to Ms. Rook's motion?
I would think like a week, because I'm already done with the parenting plan packet. I just have other stuff that needs to be.
Well, I'm going to set it out more than a week because that's not even 21 days from her original motion. So it's going to be more than a week. We're looking at a Wednesday in January.
God dang it.
I was hoping it before Christmas, but.
Not going to happen given the timing of this motion.
And not even the restraining order, because honestly, I didn't quite understand why there was even a restraining order, but there was no reason for it, I felt. But when was the date? You said January what?
The first date I could give you is January 4. That's a Wednesday at 9 a.m.
Well, this is very serious, and I have to take whatever I can, so.
Your Honor.
Yes, go ahead.
Can I say something? Oh.
If I may, I understand Mr. Clark's financial situation, and if it would be of assistance to him, I'm happy to provide him with any of the documents that he needs from the court file.
Mr. Clark, do you have Ms. Lawrence's contact information so you can chat with her about that?
I've been having problems with my phone. I'm sure I can get it. I can get if Tiff or I can get it from my mom. If not, Tiffany can text her number to my mom or something.
Call you, Gareth.
Okay.
Okay.
Sorry, Ms. Lawrence, I don't think he heard what you said.
Oh, then I can contact him. I've got his number, so I can contact him. If the number on the screen is accurate, especially, I can contact him, no problem.
Okay. So Mr. Clark, is this your phone number ending in 6972?
Yes.
Okay. Ms. Lawrence, yeah, ma'am, I'm coming to you. Hold tight. I'm still in the middle of a sentence. Ms. Lawrence will reach out to you, Mr. Clark, okay?
Thank you.
Okay, Ms. Rooks, go ahead.
So when we had court on the 6th, I asked you, can I go back from November 22nd when I first served him? And you said yes. So then that would have been 21 days.
No, it would not, because what we talked about was you had to provide proof of service that he was served 21 days before the hearing. You provided proof of service dated December 7th. The proof of service you filed in one spot on page 1 says the date and time he was served, 12/blank/2023. So I have no date to go on, except I know that he wasn't served in November based on that proof of service. Page 2 is dated by the person who served him. Hold on, December 7, 2023. So going from December 7 to December 20 is not 21 days.
Okay.
So we will see you back on January 4, 2023 at 9 a.m.
Yep. Thank you.
Hold on. January 3rd. I'm mistaken. It's not the 4th. That's a Thursday. It'll be Wednesday, January 3rd, 2023 at 9 a.m.
All right. Thank you.
Thank you. We'll see you then.
Thank you, Your Honor.
Thank you. I think today, if I am not mistaken, we're reviewing just an interim GAL status. So Ms. Corey, maybe I'll first turn it over to you, and then that may dictate where we go this morning.
Yes, I believe that's correct. I actually have January 31st as the final GAL review date.
I have that.
And this was to be a review after hair follicle tests were ordered for both parties. And I have received those from both parties. Ms. Zimmerman's test was completely negative, and Mr. Zimmerman's was not. His hair follicle test found for the presence of amphetamines in quite, it appears to be quite a ways over the limit that they use for a cutoff. Other concerns, there is one other concern that I have, and that is regarding Mr. Zimmerman's girlfriend, who I learned after looking at Odyssey. She is just about a 2-year-old third-degree assault charge that she was found guilty of. And I have not yet been able to get those records, but I will be reviewing them in the future.
So this Mr. Zimmerman, 2 slightly concerning points here, and I'm going to come to you in just a second.
Okay.
But I want to go to Ms. Zimmerman first. Thank you for doing the hair follicle. I'm very glad to hear. Well, Mr. Zimmerman, there's someone nearby you talking that the court is hearing. So go ahead and mute yourself and tell them I'm calling on you. So Ms. Zimmerman, I know one of the things that instigated all of this was your housing situation. What can you tell me about that now?
I am moved into my new place, 3-bedroom. The living situation was just temporary. The kids have their own rooms and we're happy.
And are the kids back with you now? I know the parties had agreed previously that the children would reside with the father because of housing issues pending further review of this court. Are the kids back with you now?
I guess I'm just waiting to hear from the courts what is best. Right now, they are with me physically. Okay. And from the last court date, I was just sticking to the original parenting plan that we had originally signed off of and plan to return them 10 o'clock at night on Christmas Eve because that's what it says on the original.
Okay. So I am going to change the interim bench order we had, indicating that the parties had agreed the children would reside with father until further review of this court. I'm going to change that to indicate that they are to reside with mother at this time. Mr. Zimmerman, what would you like to tell me first about the hair follicle test?
I am on prescribed high doses of Adderall from my prescriber. The last couple of months, they have upped and lowered and then re-upped my amounts taken. They're testing the amount that is more beneficial for me. I have 2 different prescriptions of Adderall that I am prescribed that I take on a daily basis. I have 30 milligram extended release plus 220 milligrams that I take throughout the day as a booster. So that alone right there is going to be high amounts that is going to be in my system.
And I don't have the benefit of having that report in front of me. So I really can't make a judgment about whether a prescription for Adderall would cause that kind of result. Is there any indication, Ms. Corey, in the report that they address that issue at all?
Typically in the reports, if there is a prescribed medication that may be affected, it's noted in the report as an expected result, and that was not noted. However, Mr. Zimmerman, in his intake for me, did list Adderall as one of his medications.
I also sent a picture over via email of my prescription medication list.
But Mr. Zimmerman, did you discuss when you went in for the hair follicle, did you discuss the prescriptions that you?
Yes, I've used their services before for on-the-job injury as well as testing for a new job, and they had that all on documents is what they told me.
Are there any positives beyond the amphetamine?
No.
No? Okay.
And I can show you my prescription bottle right now on camera if that would be beneficial.
No, it's okay. I think what I'd like to do though is just have you reach back out to them with your prescription and the amount. They can do a supplement on whether then the positive is an expected result given your prescription.
Okay.
Okay. I think that will be really helpful for the court. The second question does involve an individual. So is this significant other at this point or girlfriend residing with you?
No, she is my fiance. She is not residing with me. She has her own place. She's when the kids are here, her and I are usually together. I don't leave my children with anybody. So yeah, no, we don't live together. She has her own place of residence. I have mine. She's in all the services that she needs to be in. She's doing absolutely fantastic.
Was this, and again, I don't have the benefit of any of this in front of me. Was this an assault 3 conviction?
Yes.
She's in DV classes. She's in treatment. She's lives in a program house called the Phoenix House. She has more clean time than I do when it comes to paperwork. So yeah, it's.
Ms. Desiree Zimmerman, was this information that you're aware of? Do you have concerns about? What is your perspective? Mr. Zimmerman, I'm assuming that's your fiance in the background that I keep hearing. She's not a party to this case.
Nobody's said anything in my house. The only person that spoke was me, unless it's my TV in the background. I muted it.
Ms. Desiree Zimmerman, can you hear the court?
Yes.
Okay. Were you aware of some of this information regarding the fiance?
Absolutely. My kids have expressed their opinions on it. At first, they really liked her, but as of recently, they feel like her demeanor and stuff has changed more aggressively towards their dad and has made them feel uncomfortable, which is a little bit concerning.
So with regard to, and I'm just going to go back right now, just a second. I'm pulling up your original final parenting plan, the one that would still be in effect until we do something new. They reside with you, and then they have visitation with him they go to him on Wednesdays. Is that what is still happening?
That's the usual one, but it's a little bit different.
What do you mean it's a little bit different? Ms. Zimmerman, can you still hear me? We can't hear you.
First half.
Well, Ms. Zimmerman, you cut out.
And sorry.
Sorry, you're gonna have to start all over. After I ask my question, you cut out.
Is that better?
It is for now. Yeah. I'm just trying to ask what you're currently doing with visitation.
I planned on dropping them off 10 o'clock at night, Christmas Eve. And so that way he can have the kids for Christmas Day. I did want to bring a couple things up.
Well, hold on. Yeah, just hold on a second. But when it's not Christmas break, are you all switching kids on Wednesdays?
I just last Friday got the keys to my place, but I do plan on doing that and being consistent with that.
Are you asking for any temporary changes to that, knowing that the fiance will likely be around during those visits?
I've just had talks with my children that if something were to happen, physically aggressive or to where they felt unsafe, to call 911 or call me. They're both at the ages to where they're capable of doing so. And I just tried to have some kind of trust in Chris, that he wouldn't allow something like that to happen to our children. And just hope for the best. I mean, I don't agree with a lot of his choices, but I do still want him to have a relationship with his children.
Okay.
So.
Okay, we'll come back to that in a second. Ms. Zimmerman, you said there were other issues you wanted to discuss. Go ahead.
There's been a couple times now that Chris has been late with picking our youngest up from daycare. And because the daycare is in my name, I've had to pay those fees off, and I haven't received any kind of payment back. That would be one of them. And I have to think of the other thing I was going to bring up. I forgot now. I'm sorry.
Mr. Zimmerman, what's happening with some of the late pickups?
So the first time I was in the middle of an appointment and I was late. So the appointment was supposed to be over with, and I didn't think to call Desiree and let her know. So as soon as the appointment was done, Desiree called me. I ran over there and grabbed him. And then the second time I was literally connecting my new cell phone that I have, and it was rebooting in the middle of another appointment. And so I wasn't able to call her and let her know this time. So as soon as my phone rebooted, I was already on my way there. She said she was already there. I met her there and I picked him up. I'm also getting a substantial check today from L&I due to a work-related injury. And I already told her I was going to pay her back. We already discussed all this. And to the fact that with the fiance thing, her and I have never even gotten to a verbal fight. We've never argued with each other. We've always had strict communication, peer communication. She has moments where she's grumpy. I mean, every human being on this planet, she's lives with her 2 children. She's regaining custody of her youngest son through CPS. And so she is literally doing everything she's supposed to be doing. She has had a couple of grumpy moments, but every human being in the world is going to have grumpy moments. But other than that, we've never fought. We've never, argued about anything.
But she's the woman that's around your children has lost custody of her own children. Is that what you're telling me?
Desiree and I have lost custody of our own children. People change.
They're your children. These are your children. So I'm just, your children's biological mom has a right to be concerned about other folks that are in her children's life. So in my bench order today, I'm going to indicate that just pending full GAL investigation and reports, parties are temporarily going back to the children primarily residing with mothers, or housing situation is stabilized, and her hair follicle test is negative. Father shall not leave minor children unattended with his fiance at any time during his visitation time. I mean that. I mean, not even, I'm talking, it's not you slipping out to the grocery store and your fiance is watching the girls. It is truly your co-parent, Ms. Zimmerman, trusts you with the children. She does not have to, nor should she right now, trust your fiance with her children. So at all times when the children are in your care and custody, if your fiance is around, you are to be there. I understand the age of the children. And so if your fiance is at home and you need to jump out to the grocery store, I'm not saying your kids can't ever be home alone. I am saying if the fiance is there, you are to be there as well.
I understand.
Sounds like the other issues with pickups and that sort of thing have been addressed. Is there anything else we need to do today?
Yes, there is one thing that I do have a concern of is the gentleman that my children's mother have been having my children around, convicted felons, active addiction. That is a huge concern for me. I was just informed about the information a couple of days ago about the gentleman that Desiree told me she was looking to try to get into a relationship with. And so I never had a chance to reach out to the GAL because I worked yesterday and today is Tuesday or Wednesday. So it's a big concern for me. The gentleman that Desiree's been seeing is far from a good person, and I would like the same thing done in the other direction if possible. His name is Scott, and I can allow the GAL to do her part in that.
Mr. Zimmerman, I didn't ask for your fiance's name for very specific reasons.
Oh, I'm sorry. I didn't think about that.
Throwing someone else into the mix that frankly, I don't have any information on. Ms. Corey, is this anyone that you're aware of?
No, it's not.
Okay. Well, Mr. Zimmerman, if you want to present that information to the GAL, we can address it at a subsequent hearing. I have no information about this that would independently verify any of the things that you're stating.
Understandable.
Can I speak for a second?
Go ahead, ma'am.
I am not in any kind of relationship at all, nor do I plan on being for a while. I was just trying to be in an open communication with him and letting him know that this person was someone of interest in the future and a possibility. And the only time that I really had him around the children was the day of I had to rush over and grab our son from daycare. It was unplanned. I had actually even expressed to Chris I was going to be unavailable that day because that was the day that I was moving and I was receiving help from my friends with helping move stuff. So
I'm not taking action on any of that today. Again, Mr. Zimmerman can present whatever evidence he would like to that regard to Ms. Corey. She will certainly follow up on that as she does her report. I think our next review is the 131, the January 31st, 2024, 9 a.m. Does that sound right to the parties?
Yes.
Do we need anything in between those dates for review?
I don't believe so, Your Honor.
Okay. Okay. All right. We'll see you back January 31st, 2024. Thank you all.
Good morning. Thank you, Your Honor. I'm sorry for the delay.
Not a problem. We still have plenty of docket to go. So I understand, I did see your recent notice of appearance on this matter. This was originally scheduled on for my review of temporary orders. I have reviewed Ms. McLean's proposed temporary orders and the declaration of her client. I didn't see any response yet from you. So Mr. Gross, how are you asking me to proceed today?
I'm asking you to reset the hearing, Your Honor. Of course, Mr. Smith and I need an opportunity to respond and fully inform the court so you can make an informed decision about this matter.
And how much time are you asking for?
Well, considering where we are on the calendar, I think into the week of January 8th, I've got a series of hearings, et cetera, set for the week right after the 1st. So if we can move into the week of the 8th, that would be most helpful, Your Honor.
And Ms. McLean, I'll turn to you.
I have no objection to that. Of course, I'm going to need an opportunity to meet with my client and to be able to prepare reply declarations. So I guess the question for counsel would be is whether or not he expects that he can have his documentation to us by this next week so that we have a week to respond.
Sorry.
That's okay. I'm actually going to be out of the state all next week, and then I go into a 2-day trial the first week of January. But I can work remotely on vacation, I guess. So in the meantime, though, the other concern would be is that we would want to make sure that the status quo is maintained as far as the payments that Mr. Smith has been paying and the visitation that they've been exercising since September, which is essentially outlined in my client's proposed parenting plan, which is the first, third, and fifth weekends from Friday to Sunday and every Tuesday overnight. We would also ask that there be, if not an order, at least a discussion with Mr. Smith about not discussing the pending litigation with the children and not introducing them to his new significant others.
And we'll talk about dates in just a second. Mr. Gross, it does sound like at least informally the parties have been engaged in a visitation schedule and some form of payment. Is that going to remain? I mean, I'm not issuing orders, but I think counsel's asking, is that remaining through the date of our hearing on temporary orders? And I think that may dictate how quickly we need to get this heard.
Understood. Mr. Smith and I have discussed this. Of course, he's not going to put anyone at a financial disadvantage until we get into court, and the court can determine where money is supposed to be going. So that will remain unchanged. The visitation schedule is not as much as or by agreement as Ms. McLean may believe, but unless the parties can agree to something else, it will continue as it has.
So the other complicating factor is I won't be doing this Wednesday docket in 2024. So, and since you all are pre-assigned to me due to conflicts, we'll have to find a place to put you. The most likely is going to be a Monday. Well, let me check with the clerk. I'm about to say Monday at 1 o'clock or Friday at 1 o'clock. But I'll need to make sure that we would have a domestic clerk available. Oh, wait, back here. Okay. So I think what they have been doing is trying to place these types of cases on my Friday 1 o'clock trial time. Is there a Friday starting? I'm out on the 12th. If you all wanted the 19th, I can make that work at 1 o'clock. If you want to get in sooner, I could take a quick break and ask court administration about availability on Monday, the 8th at 1 o'clock.
I could do Monday the 8th. I could do Friday the 19th.
Either one is fine with me as well, Your Honor.
Okay. I know that the 19th at 1 o'clock will work. Does anyone have heartburn waiting that long for it?
So long as we maintain status quo.
Okay. And obviously, if that doesn't seem to happen and you need to get this noted on for the 8th, you all can reach out to court administration, copy me on an email, and we'll get it done.
Thank you, Your Honor.
So for now, I'll move you to January 19th at 1 o'clock. This will be a special set under my trial time. I'll shoot an email to court administration now, just so you all don't get any questions about why this was set on that date.
And then also,
oh, go ahead.
So just for counsel and my future understanding, how do we schedule on with you? Do we just need to email court administration and ask for that? Do I need to note it up on trial assignment dockets and get a special set?
Yeah, I would say, well, trial assignment docket would be fine because in 2024, I will be doing all trial assignment dockets. So you'd be working with me to set on my calendar. So that certainly is one way. Or
so if we did that, could that be on a week's notice, or are we having to give 3 weeks notice for a trial assignment to set a motion?
No, if you all are in agreement on the date, the Wednesday 1 o'clock trial assignment docket, just set it. Yeah.
Okay.
worry about that at all. If something comes up, because this is unusual, given the number of judicial officers that have had to conflict out, if you want to email court administration, but CC me about proposed dates, giving proposals for Monday at 1 or Friday at 1 will be our best bets. And then I can just quickly work with them on what works.
Okay. Okay, council and I should be able to work those out, I'm assuming, so.
Okay. Yeah, a little bit unusual, so thanks for working with us on that.
Okay.
Okay.
All right.
Thank you, Your Honor.
Is it inappropriate of me to ask about an email that I sent to you on another case?
No, go ahead.
Can you get back to me on the McCoy case? It's Brandy Jeffers and I sent you an email a couple weeks ago.
Let me look real quick. Just give me a second. Regarding the MSC.
Yes.
Okay, perfect. Thank you.
Okay, thank you very much. I appreciate it. I'll let Ms. Jeffers know.
Okay, thank you both. And Heather Lucor. I'm just gonna. Good morning. No,
Morning.
This file here. My understanding is both of you. Tell me if I'm wrong, but I think both of you have filed for restraining orders.
Yes, Your Honor.
The restraining order that I filed is not a no contact restraining order. I think that's the main difference. It was more just don't harass, and it was the two other parts of the restraining order minus the no contact, because I don't want my daughter to not have contact with her dad.
Okay.
I've co-parented for 6 years, no problem.
Understood. And then ultimately on January 3rd, I believe you all have on the docket temporary family law orders you're asking the court to consider.
Correct.
So I'm just making sure I don't have this wrong, because the notes on my docket relate just to the restraining order requests today. And then February 3rd, you'll be addressing the temporary parenting plan proposal. Does that sound correct to you all?
Yes.
Yes. And I also sent out a motion for January 24th.
Okay. What is that motion for? I don't think
it's actually for the temporary parenting plan. I believe I sent you bench copies.
Let me get into my bench copy list here.
May I mention something too whenever you have a second?
Yeah, just a second. Okay, we did get, I do see that January 4th, 2024 is your request for the temporary parenting plan. And then January 3rd is Ms. Lucor's proposed parenting plan. Ideally, we'd want to combine those. Let's just start with that. Give me a second. I've been standing this whole docket. I'm going to sit down for a second. Rather than bifurcating on the 3rd and the 24th, I'm sure the judicial officer would be appreciative that they would be deciding the temporary parenting plan at one hearing, taking into account both of your proposals. Would you guys have an agreed date that you would want to do that? And we could make a note that, both of those are done on January 3rd, but Ms. Lucor, I don't know if essentially you'd kind of be waiving that 21 days notice that's typically required. Or we could pick a new date for both of your parenting plans, or we could move them both to January 24th.
I believe I haven't seen the paperwork yet. As far as his proposed, I would be okay with keeping it on the 3rd though, I believe, since I think that I have all of my paperwork in that I need to have in for that.
Okay. And Mr. Denlocker, would you be in agreement to have your documents, because Ms. Lucor is agreeing, have both your temporary parenting plans looked at on January 3rd?
She has not had time to review any of the temporary parenting plan. I have not served her with it yet. Okay. And so there would be no proof of delivery within 21 days. That's why I put it out to the 24th.
Okay. Well, I was trying to help y'all here, but we'll keep it the way it is. Ms. Lucor, I don't know. I'm guessing when you come on the 3rd, the judicial officer may want to bump them both to the same date. So maybe the two of you can talk about whether you want to agree on a date that's maybe the week after the 3rd or something like that. I'll let you guys work that out, but right now it's Ms. Lucor's motion on the 3rd, yours on the 24th, but really you're both asking for the same ruling, that is a ruling on the temporary order. So I think the judge is going to want to hear it all together rather than bifurcating. But anyway, that's for another day. Let's talk about the restraining orders. Since I received it first in time and there is a temporary order in place, Mr. Denlocker, I'll first hear from you about why you believe this is necessary at this time. Do you intend to give any additional testimony or rely on what you have submitted to the court already?
I do have some other character reference pages to attach, but I have sent you bench copies prior to our last meeting for court last Wednesday that has information, emailed statement from Heather Lucor's coworker and friend, Ellen Jordan.
Yes, I have received that.
And I have asked for a hair follicle test from Heather Lucor. I'm wondering if she has fulfilled any court order requirements. And then going into our daughter, Heather in 8 months has overslept, not getting our child to school. Our daughter has 24 excused absences, 12 unexcused absences, 54 tardies, and a total of 36 days absent in 8 months. I have also attached paperwork from the school stating that they were going to take her to juvenile court over said issues. What my question is if Heather doesn't have a drug problem, but why is there the neglect going on?
Anything else you want the court to know?
Well, I guess not as of right now. I mean, the other things could be addressed with the temporary parenting plan.
Right.
I'm concerned about our child and what's going on. There's multiple people that have been asked by her landlord to not be over anymore. I'm worried about people that she's surrounding our daughter around. And then I've also attached in my bench copy for you last Wednesday, 11 UAs that I have taken as of recently. Actually, the last one was the Tuesday before last Wednesday. I attached that as well. And those are all at random. I have to make a phone call every single day to find out if I go in or not. So I just want to prove that I'm capable of taking care of our daughter. If I'm not trusted, then why would she leave our daughter with me when she went to Tennessee?
Okay. And Mr. Denlocker, I don't know, you probably haven't received it. I just got it this morning. It was filed this morning. It is from Ms. Lucor, and it's a 10 drug screen urine analysis result. And it is completely negative.
Okay.
And I would not assume that you would have that information because it was handed to me just now. So I just wanted to let you know.
That's great.
Yeah, Ms. Lucor, go ahead and first, as it pertains to the request for a restraining order, we've done a temporary one, but this is your time for a hearing on the, I guess, more substantial restraining order, one that would last longer. I assume you're objecting to that?
Yes.
And why are you objecting to it?
Well, to start off, Emmeline has lived with me and had the same address as me her entire life. Brian and I have been broken up for around 6 years now. We have co-parented this entire time with no problems, no accusations of drug use or substance abuse, minus more so on his account from having multiple DUIs. And I have never been away from my daughter for more than 3 days in a row her entire life. So all of a sudden having a month-long stretch of not seeing or being able to talk to my daughter was incredibly difficult, I guess, to say the least. The attendance records, yes, I definitely admit last year I was struggling with a lot of mental health issues, as well as multiple people between my family and my boyfriend had passed away, as well as I had moved twice within 1 year. Actually, within 6 months, I had to move 2 different times because my grandma sold her house. And then we got a notice saying that our landlord was going to sell the house 3 months into us living into the new house. So we had to move again. That is not an excuse, but if you look at her records as of this year, she has had in 74 days, she has had 5.33 days excused absences. It shows, which 1.33 of that was since Ryan has had her. I was going to file this as well today. I just did not have my wallet with me as far as paying for the cover sheet. So I will file this as well, just so you have the updated copy of the attendance record. But as far as in the last 3 months, her attendance, she had missed 4 days total. She also received a SOAR award this year as far as her academics went. And my biggest problem is that if you look at the text messages between me and Ryan when I was in Tennessee with my grandma, because she was in hospice and she was expected to pass away, I 100% trust Ryan to watch our daughter. That's why my restraining order is not a no contact, because I believe this whole thing is detrimental to Emma. Ryan knows it is 100%. He has never once acted concerned about me taking care of our child. And so for him to, out of nowhere, because I refused to pay back child support, he threatened to take her. And I was in Tennessee, so of course there was nothing I could do as far as filing anything during that time until I got back. And I have multiple records of me calling over and over, me messaging him and pleading with him and his mother to please let me have contact with our daughter, because like I said, I've never went more than 2 or 3 days without talking to her or seeing her. And there's absolutely no valid reason to have a restraining order against me. And I will get him the copies of the urine analysis. I had called multiple places as far as a hair follicle. I did not find a place in town that did it specifically, but I just made the appointment about a week and a half ago, and that was the soonest they could get me in, was yesterday. So I got the results in as soon as I possibly could, but I will serve Ryan with the copies of that as well as the updated attendance sheet. I don't know if he kept Emma there again today. I saw that he had kept her home last Wednesday. I'm trying to think if there's more that I should add, but I just really, really would love to have her home, because this is her home, regardless of what Ryan is trying to act like or state and act like. Her home is with him, because they can't even legally really live where they're living at right now, because it's a 55 and older community with his mom in a 2-bedroom place with 4 different people. So she has her own room here with her own bed and her own space. And we have lived here for over a year now.
So here's going to be my ruling on, first we'll do Mr. Denlocker's request for restraining order. And although, yes, sir, go ahead.
May I add?
Sure.
The statement about our daughter never being away from her longer than 3 days is false. I've taken my daughter on camping trips for weeks at a time.
All right, I'm not basing my ruling on that at all.
May I?
No, sir, I'm making my ruling on the restraining order based on pertinent evidence as it pertains to the restraining order.
Yes, Your Honor, I would love to add something, please.
Go ahead.
The reason why I put a hair follicle test in place in my paperwork is because it tests back longer. The drugs that I'm concerned about her using leave your system faster than others. I'm talking like 3 days or something. So that is why I've requested a hair follicle test, and I've added that in all my paperwork.
Thank you, sir. All right. So when a person is requesting a restraining order, I must find that there's some real, more likely than not, meaning 51% chance or more, that there is a danger to the child should I not put the restraining order in place. If you're filing a full civil protection order, I have to find that there's been some act of threat of harm or some other type of unlawful harassment that has occurred. Although the standard in family law restraining orders is somewhat lower, and I am looking at what's in the best interest of the child, I find no credible evidence beyond allegations that a restraining order is necessary in this case to protect the child. I find that these parties absolutely should move forward with their request for a parenting plan, that within that request for parenting plans, if the parties want to ask the court to order hair follicle testing at the before visitation occurs, and if it is positive, then visitation is to cease. That is certainly something that the court can decide on at the time of entering these orders. But I will find in this case that this isn't a situation where one parent may have a substance abuse issue and the other parent never has and is doing great. I mean, the thing is, I understand why both of you may have concerns about the other parent, but none of it rises to the level for me, based on what has been presented to me today and prior to today, none of it rises to the level that I would issue a restraining order completely denying parenting to someone who has parented a child for many, many years, despite absences at schools. That's concerning. It's not restraining order concerning. I understand, sir, your comment about hair follicle test going back further. The screen I have in front of me was collected December 19 at 4:55 p.m. What that tells me is that at least currently, the child would be perfectly safe with Ms. Lucor. So I am declining to grant any further continuances on the restraining order. It will be denied as of today. Ms. Lucor, I want to ask you, given my ruling, are you still asking for your restraining order case to move forward?
Yes, I am mainly just worried as far as, because with it not being a no contact, I still want her to have contact with him. I worry mainly because of him continuing to discuss all of the issues he has with me, with our 8-year-old daughter. And I'm hoping that with what I put in the restraining order, as far as not harassing and not, all the different points in it, that would cover as far as him not being able to do that to our daughter, correct? That was basically my understanding of the restraining order.
You still have to prove that a restraining order is warranted. And I haven't heard that from any of your all's testimony today from you or from him. So I'm not inclined at this point, based on what's given to me to grant any party a restraining order. If you have additional evidence about why you believe he has harassed you or the child, I'm happy to hear it. And then I'll give him a chance to respond. But if it's just based on the evidence you all have already testified to, I am inclined to deny.
Okay. Yeah, the only evidence more that I have would really be if Emmeline were able to talk as well into it. But no, without her testimony, then no, I don't really have anything else to add.
Okay. Mr. Denlocker, anything else you want me to know about the request for a restraining order against you?
Yes, Your Honor.
Go ahead.
Heather's ex-boyfriend that she was referring to that died, he had a severe drug problem. They did not have a healthy relationship. Our daughter was around this a lot. This guy, it is not a healthy situation over there. My daughter our daughter, excuse me, wants to live with me. And she has told her mother that. As far as my living situation here, I actually just got the keys to a new place yesterday, and it is a 3-bedroom house with a garage, a big yard. Emma would have her own room. The reason why we are over at my mother's, which is a 3-bedroom house, was just temporary because of this whole situation.
Okay.
My mother is terminal, and I take care of her.
So again, there's nothing I've heard since we talked about Mr. Denlocker's restraining order that would change my mind. I do not believe a restraining order against either parent in this case. I don't believe the burden has been met to show that that's necessary to protect the child. So I am going to deny Ms. Lucor your request for the restraining / anti-harassment order. You all, that takes care of the two issues that were in front of me today. You all are scheduled back in front of the court January 3rd for now on Ms. Lucor's motion for temporary parenting orders. Is there anything else you need addressed today?
Your Honor, I would request Emmeline to stay with me until things are resolved in court.
I'm declining to enter that. I've removed the restraining order. So whatever visitation and custody issues were in place before the restraining order are automatically put into place as of 10:40 today. You can readdress that with your request for temporary orders.
So since I have normally had her Monday through Friday, I am allowed to go pick her up from school. Like, we don't have anything in place. Technically, we don't have a parenting plan. We don't have a custody, nothing. In the past, I have had her Monday through Friday. He has had her Friday after school until Sunday. That has been our schedule. We don't have it in writing, but that has been the case since she's been in school. And so I know that you're saying that.
Well, here's the thing, y'all. My hands are tied because both of you have requested this court enter a temporary parenting plan in January. No one has timely put that in front of me for today.
Right.
Well, did put in front of me for today is restraining orders. I do believe you all are about to embark on a real bumpy road between now and January when you do have temporary orders in place. I can't fix that though, because that is not in front of me to decide today. And I am not going to without both of your materials have been served and exchanged. I can't address that issue for you. So unfortunately, you both are in a situation where there is nothing in front of me today that can fix or remedy what you all are about to go through between now and January 3rd or now and January 24th. I can't enter orders. Again, like Mr. Denlocker, you stated, you haven't even served her with your proposed, so I can't.
No, I have with the proposed.
I encourage you both to work together to get through the next month. I absolutely believe wholeheartedly that neither one of you should be talking to the child about this case or asking questions like, what do you want? Who do you want to live with? If you live with me, we'll do this. If you live with him or her, this will happen. I really strongly encourage you both. And I think that you both, given what I've seen in your filings, you both absolutely love and want the best for your daughter. So over the next 3 to 4 weeks before you have temporary orders in place, just remember that and try to work together as best you can. I can't issue orders today about custody.
May I ask if he kept Emmeline home today again? Because he kept her home.
Ma'am, you guys will have to talk about that after docket. Okay.
Your Honor.
Yes, sir.
Our daughter is very, very scared of her mother right now. She has told me that if she goes to school today and the restraining order is lifted, if her mom shows up to pick her up from school, she's going to ask the school to call 911.
Well, sir, I cannot control that. Nothing has been asked of me in a timely manner today for me to enter temporary orders. You all brought restraining orders. I ruled that I did not believe there was sufficient evidence to enter orders of restraint against either one of you. You all are back in January on temporary parenting plans. Again, I wish you the best of luck. I obviously can't control if an 8-year-old tells the school they don't want to go with their mom, but I can't insert myself into that without proper jurisdiction to do so.
Did we resolve the court date for January?
You have January 3rd and January 24th.
So both dates.
Both
will
dates.
stay.
Okay. Yep. Okay. All right. I wish you all the best of luck.
Thank you.
Thank you.
Thank you.
I missed it.